Okay, welcome everybody to this virtual lecture by Professor Kimberly Jenkins Robinson of the University of Virginia School of Law. I am John Taylor. I'm the interim dean of this institution, and I'm quite confident that no one is here to listen to me, so I will be brief. Today's lecture is both our annual Charles L. Ihlenfeld Lecture and our observance of Constitution Day. A few words about each. The Ihlenfeld Lecture is devoted to important issues of ethics and public service, and it's funded by a generous gift from Charles L. Ihlenfeld, who was a leading lawyer and public servant in West Virginia. He was a 1933 graduate of our College of Law, whose career in the law spanned nearly 60 years. Charles Ihlenfeld loved his home city of Wheeling, West Virginia, and during his career, he served both as a member of the Wheeling City Council and as mayor. He was also prosecuting attorney for Ohio County, West Virginia, and he also served as a United States Magistrate Judge for the Northern District of West Virginia. Charles's son, Bill Ihlenfeld, is a 1965 graduate of our College of Law, and his grandson, Bill Ihlenfeld II, is a 1997 grad of our law school. Bill II has served as the U.S. Attorney for the Northern District of West Virginia, and he's currently a state senator as well as special counsel at Bowles-Rice. So the legacy, the family legacy of public service lives on. Normally we would be in person, and I would ask the members of the Ihlenfeld family who are present to stand. That won't quite work today, so I will just say to all the folks in the family who are here, we greatly appreciate everything you do for the law school, and you're making this lecture possible. Second, a word about Constitution Day. It is observed on September 17th, which marks the anniversary of the signing of the original Constitution by its drafters. It became an official holiday in 2004, thanks in part to that great bringer of things to West Virginia, the late Senator Robert C. Byrd. During his lifetime, the senator was the gift to West Virginia that kept on giving. And today, from beyond the grave, he brings us the gift of Professor Kimberly Robinson. So I'm now going to turn things over to our own Professor Josh Weishart, who is going to introduce Professor Robinson.
No one's is on.
Okay, thank you, Dean Taylor. It's my great privilege to introduce my friend Kimberly Jenkins Robinson, who is a professor of law and a professor of education at the University of Virginia. She's also a researcher with the Learning Policy Institute and the Charles Hamilton Houston Institute for Race and Justice at Harvard Law School. Professor Robinson is among the nation's top education law experts and the foremost authority on education federalism. Her scholarship envisions a reconstructed federal role to ensure equal access to excellent education for all. That vision of educational justice is informed by her background and practice experience. Following graduation from Harvard Law School and a Ninth Circuit clerkship, she practiced at Hogan Hartson, representing school districts seeking adequate school funding. She then worked as an attorney at the United States Department of Education on civil rights issues before entering legal academia, where she held prior positions at George Washington, Emory, and Richmond. In addition to all her impressive credentials and accomplishments, she is as kind and generous as they come. I could go on, but let me stop there and invite Professor Robinson to deliver her remarks.
Thanks so much, Josh, for those kind words. So I'm really happy to be here. Thank you for inviting me. And I'm sorry I can't be there in person, but we're gonna just dive into these topics today. So I'm going to share my screen and deliver some slides. Okay, hold on. 1 second. So can you see the PowerPoint? Awesome. Okay. All right. So welcome. We are going to talk today about why the United States should think about recognizing a federal right to education. So I will talk for, at least half of the time, but I really prefer to have a dialogue with students and faculty. And so I love to leave lots of time for Q&A. So I'm going to do that today. So, but first I want to make sure just that we're all kind of on the same page in terms of the background of these issues and just lay the groundwork for what I hope will be a really robust dialogue about this important topic. All right, so let's dive into the foundational case. So we're going to start back in 1973 with the Rodriguez case. And really, we should even go back further than that, but I'm going to start there, which is to say that we had school finance litigation really as a result of school desegregation litigation not providing equal access to educational opportunity in the United States. So the goal with school desegregation was not only to end the separate schools for Black and white children, it was also to ensure equal educational opportunity. Indeed, the Brown opinion says that education is a right which, if provided, if the state chooses to provide it, must be provided on equal terms. And so what's interesting about the legacy of school desegregation is we never really finished that work. You know, we started to, by integrating schools eventually after quite a period of massive resistance, but we never really got to equal education opportunity. And so lawyers, seeing that they were dissatisfied with the landscape after school desegregation, pushed on to say, well, if we can't get all the schools integrated, then we should at least have equitable resources. And so there were a number of cases. There's an important one in California, but we're going to focus here on the federal litigation. So the Supreme Court in 1973 held that the Federal Equal Protection Clause does not guarantee a right to education. And it said, as the slide notes, that it is neither explicitly protected, which of course on Constitution Day, I trust you all have read the Constitution, education is not mentioned, but also they said it was not going to be implicitly protected. So the court gave a number of reasons for that, and it's important to understand why, particularly as we think about whether we will eventually change to recognize a federal right to education, you know, in the next half century or so. It's important to understand why the court ruled the way it did and what has changed on the ground since then. So the court gave a number of reasons for why it was choosing not to recognize a right to education. So first it said, look, we are not education experts, we're judges. We're not trained to decide matters of supreme importance in education. And so they said, we just don't have the expertise or the familiarity with what's happening on the ground to make these essential questions about how schools should be funded, how funding should be distributed. And so they said, we're going to resist sort of imposing a federal standard, you know, on those issues. They also noticed that there was quite a bit of debate in the case and in the briefing of the case about certain educational issues. So those issues included an important one that I will shorthand for you about, does money matter? So one of the key parts of the case is that they said, look, you know, the lower court definitely has assumed money matters, that it matters that this district gets less and this district gets more. But the evidence at that time, the social science evidence, was quite mixed on that issue. And there was a vigorous debate about, does money matter? And what would happen is you'd point to these districts with very high funding and say, they're not getting better outcomes in this district with leaner funding. So that was a quite robust debate. And they said, you know, we don't want to prematurely interfere with what these education experts are debating. They also noted an important issue, which is that federalism would be greatly changed by federal interference into education. They said, look, we can't even imagine a case that would have broader federalism implications. And it really would have caused the Supreme Court to become heavily invested in how schools are funded. And it said we would really upset the balance of power. Federalism, it's funny, when I tell people I write about education federalism, particularly if I'm out in a social setting, like their eyes glaze over, right? But it's important to understand, what does that mean? Well, all it means is that it's the balance of power between the federal government and the state and local government. That's all the word federalism is a shorthand for. And so the important thing it says is, look, we're going to just completely shift that. If we move these cases to federal court, then the federal government gets to decide what school funding looks like, and said, we don't want to do that, particularly because they said this system, this inequity, is very commonplace. We'd have cases, you know, across the country in virtually every state. And so we don't want to upset the balance of federalism that much. They also noted that local control is an important American value. So they said, look, having funding at the lowest level, so the local level where you can have the most influence over education, is an important value for the United States and one that we want to preserve. And so they said, if we, centralize it and we require the federal government to step in and guide what the states do, that would remove some of that authority from the local level. So the court acknowledged that, look, we don't want to upset federalism in that way as well by removing more control from the local level. The court, however, did acknowledge that there were some inequalities and inequities in the existing system that they believed should be addressed. So they said, we by no means are placing our seal of approval on this existing funding system. And what they explained was that they said, we don't want to suggest that we think this system is a great one. It clearly needs improvement. But the question for us is who should do the improving? And they said, look, it's lawmakers and others in the democratic process who should do that improving. It is not us. They also noted an important argument, and it's going to come forward in another case that we're about to turn to. So they said, look, the lawyers in this case did not argue that children in the district do not have an opportunity to get the basic minimum skills necessary for the enjoyment of the rights of free speech and participation in the political process. And so because of that, because they did not make that argument, there was no adequacy argument. So it's important to understand here, I'll just pause for a minute and give you a couple terms that you'll hear come up over and over in the talk. So first, adequacy is, and this is the argument on the slide, but adequacy says, we are going to ensure that you have enough funding to achieve a particular outcome. So the current approach to adequacy is, we're going to make sure that you have enough funds to achieve the state standards. So the standards movement actually came after this, but the idea is the same. We want to make sure children have an education that will enable them to achieve a certain level, certain amount of knowledge, or here they said minimum skills. That is contrasted with equity. So equity focuses on disparities in funding or opportunity. Who gets what type of opportunity, the quality of the opportunity, and how that's distributed. Now, there's intersection between those that I'll get to later, but I want to just highlight and make sure we're on the same page with those two terms. So the court said there was no adequacy claim here. It was just merely an equity claim. And you could see why then, if they weren't sure if money mattered, why they weren't going to leap in on equity, because it wasn't proven that money did matter, right? And so after that case, the litigation was then pushed into state courts, where it stayed for over 4 decades. And so the focus there was on addressing two types of claims, equity and adequacy. Again, those claims overlap in ways I'll elaborate upon later, but the important thing is we were in state court for quite a long time. What was the result? We had some really big wins in state court, cases that declared, including in your own state of West Virginia, some courts that declared, yes, you do have a fundamental right to education. Yes, you have a right to an equitable education, or yes, you have a right to an adequate education. So there was definitely litigation where that was successful. The more successful claims were adequacy cases rather than equity cases, but both types of cases did enjoy some success. However, what litigators found, and why you see a federal case up there, is that ultimately we were not able to get to the reforms that we wanted to get to through state court. Oftentimes, you would have very long litigation happening, and when the court would find itself in litigation for decades, it would then eventually remove itself from litigation and say, look, the legislature has made some progress. We're going to release jurisdiction and allow the legislature to move forward with the governing the education system. And they would remove themselves. So we can talk if we want in Q&A about some of the state school finance litigation. But what ultimately lawyers determined is that we need to go back to federal court. And so in the last few years, what we've seen is an increase, because there weren't for years, we've seen a substantial increase in lawyers filing school funding cases in federal court. And Gary B is the first case in the United States to hold in federal court there is a fundamental right to education. So I'm going to tell you a little bit about this case. It's shorthanded the Gary B case, but the basic idea was that it was litigation in Detroit, and the complaint establishes a set of really dismal conditions and outcomes in the Detroit public schools. And it says, look, these conditions don't even allow children to prepare to leave school as literate, functioning adults. And so the court there agreed, the federal court agreed, the Sixth Circuit agreed the Sixth Circuit agreed that there is a fundamental right to literacy. What they said is, look, it's a fundamental right to a basic education that enables a child to attain the literacy. And why is that so important? In our country, because we have a democracy, you have to have the ability to engage in democracy in an educated fashion. If you're going to hold your leaders accountable, if you're going to understand what they're doing, how their policies are affecting you, you have to be able to engage in the political process in an educated fashion. And so the court noted that connection to the very foundation of our nation and said we have to make sure that children get that education. So what does that mean? The court said, look, a right to this basic right to education, right to literacy, includes the facilities, teaching, and educational materials that students need to attain literacy. So it set a very basic standard. It did not go into great detail because the goal at the Sixth Circuit was merely to define that there was a right, and they were sent back to trial where the case eventually settled. But the court here does say exactly what students are entitled to. And it's important to note what's the source of that right. So there's quite a bit of debate among scholars of where would the right lie, what constitutional provision would be the source of the right. And here in the Sixth Circuit, the court said substantive due process provides the basis for the right. And here, all of the constitutional law students will remember this test for substantive due process, which is twofold. Is it deeply rooted in our nation's history? And the court said yes. Nation's history and traditions, and is it implicit in the concept of ordered liberty? So basically here, it's important to understand that the court is saying that, look, there's no freedom without education. Like people can, completely take advantage of you and manipulate you and dominate you in new ways if you are not educated. And so liberty and education are just intertwined in ways that cannot be taken apart. And so the court noted that connection and said, yes, this is a fundamental right. Once the case was sent back to the trial court level, the case settled. However, the full court of the Sixth Circuit did eventually vacate this decision. So the case does not have precedential value in terms of it's not legally binding on the Sixth Circuit. However, it does provide a roadmap, a clear roadmap if a future court wants to uphold the decision. But there, the full in-bank court voted to rehear the case. But because the case had settled, there was no case or controversy for them to litigate. So that brings us to 3 questions that I'm going to talk about today. So first, in the book that I recently published, which looks at a federal right to education, there are 3 questions that I focus on. And so I'm going to just highlight what those questions are today and just what some of the possible answers are to those questions. So the 3 questions I'll just shorthand as why, how, and what, right? Why should we think about recognizing a right to education? How would this be accomplished? And what should it guarantee? And these are important because it's really been, several decades, really ever since Rodriguez, that scholars have been saying, oh, we should overturn Rodriguez, or oh, there should be federal right to education. It's like, well, so what would that look like? You know, like once you get into the details of debating with people what that should look like and how it should be done, you get a lot of disagreement. So a lot of scholars do think there should be a federal right to education. Many think there should not. But for those who do think there is, there were a lot of unanswered questions. And so this is why I undertook the book project. So I'm just going to talk about these three questions. And then I'm going to just highlight a few things that are happening at the state level in West Virginia that you should be aware of. So here's an important place to start, which is the effect of concentrated poverty. It's important to understand this because this is why the funding distribution matters so much. So if you look at this poem, I'm going to just read it briefly. So this is a student writing, and he says, "I woke myself up because we ain't got an alarm clock. Dug in the dirty clothes basket because ain't nobody washed my uniform. Brushed my hair and teeth in the dark because the lights ain't on. Even got my baby sister ready because my mama wasn't home. Got us both to school on time to eat us a good breakfast. Then when I got to class, the teacher fussed because I ain't got a pencil." So think about that. Think about what this student is conveying to you about his life, right? And so what I'm portraying here is the constellation of factors that accompany concentrated poverty. And so concentrated poverty often creates less stable home environments, less stable work for the parents. Parents might be working, one or two jobs. There's less support in the home to enable students to be able to access a variety of extracurricular or other activities. And you see some basic fundamentals that the student here is lacking. And so when that student arrives in a school building, they bring with them that constellation of challenges to the classroom. And so what the research is, so I always concede when research disagrees, there's a debate in research, but the research is there's a strong consensus that students who live in concentrated poverty need additional resources. And so funding formulas need to succeed in schools. So funding formulas need to account for those needs, the constellation of needs that you see portrayed in this poem. And so one of the reasons that, as I mentioned, that litigators have returned to federal court is because they weren't seeing some of the things that I'll highlight here. So first, states have not consistently made a commitment to equity or adequacy. And so because of that neglect, we are looking for a federal forum that would give each child a chance to say, my state is not providing me the education I need. And so the importance of the federal forum matters because even in states where there has been successful litigation, one, oftentimes that results in improvements, but unfinished business, right? And then two, there are states who have rejected claims altogether and said, this is not the place of the courts. The courts should not interfere. They should defer to the legislature. This is non-justiciable. We're not going to wade into this here. And so what happens is those children and families are left without a remedy. They go to the legislature, who's the same one who created the system that's inequitable or inadequate or both. And unless they have the leverage to get the legislature to change the formula, they're left without a remedy for the education they're getting. In addition, as the Gary B case recognized, we need an educated citizenry to make democracy work, and we need to have educated workers in the workforce. This is essential. And finally, a federal call to action, a federal right to education would invest federal resources into a broken system. And so that would include first, just if you have litigation around it, it's the federal courts who are investing in it. In addition, a federal right to education also could provide the occasion for additional congressional investments in education. So how might we get there? Clearly, the courts are one avenue. You could overturn Rodriguez, or you could have one of these new cases. There's a case going through in Rhode Island. There's other litigation in federal court. So you could have the court recognize it. You could have a court, and ultimately the Supreme Court recognize this. Many think, and the book shares an excellent chapter from Derek Black about originalism and how even from the very foundations of our nation, education was essential to our democracy, and that even originalist judges, those who are originalists or those who might be more conservative, would find that our history does support the right to education. In addition, Congress could step in and pass legislation that provides a right to education. It did so for children with special needs, and it could do so again for all children to say, look, every child should get access to an excellent and adequate education. And finally, there is you could also amend the Constitution. That is a long and difficult process, but it's certainly one possibility for allowing recognition of such a right. All right. And we can talk more about the pros and cons of each of these methods during the Q&A. But finally, the other question I want to talk about, and then I'll talk briefly about West Virginia, is what should the right guarantee? And so the right should can guarantee a variety of things, and scholars do not agree on what the right should guarantee. So Linda Darling Hammond, who's an educational expert, has written an excellent chapter about the essential educational resources that students need. And so that includes things like a highly qualified teacher, well-trained principals and other staff, the resources in the classroom, textbooks and other things. So that is really essential to having students succeed in school. So that focuses on inputs, looking at what kids need in schools to be able to succeed. Second, you would have, I have another chapter that talks about the right to compete. That would include ensuring that students such as the one that wrote the poem that I showed you have the ability to compete with their more affluent peers. And so Rachel Moran provides an excellent discussion of why the right to compete should be included in a federal right to education. We also have a chapter about equitable and adequate school funding. So at the heart of these discussions is a focus on how schools are funded. And so the concern is, if we are going to provide educational opportunities that guarantee every child an equitable and adequate education, then we must ensure that school funding is designed to accomplish that. So that's really important. And then finally, your own professor, Josh Weishart, has written an excellent chapter that the equal protection and substantive process clauses could be looked at synergistically to provide both an equally adequate and an adequately equal education. In other words, we need not choose one or the other. And too often there's scholarship and cases that say we're going to focus on one or the other, but really you need both for education. You don't just need one or the other, and the two can be married together. All right, so let's talk a little bit about West Virginia. First, you have a high level of poverty in Virginia, as you well know. So you have the fourth highest poverty rate in the United States. About 10% of the poor students live in high poverty districts. And so you have a significant one of every 10 poor children lives in concentrated poverty. That means poverty that is, throughout the community, and that is affecting them in the ways that I highlighted in the poem. And then I've included just some deep demographics for what the population looks like. But let's look at how funding is distributed. So first, when you look at the 2006 to 2007 to 2016 to 2017 school year, you see some patterns. Great news. West Virginia is working really hard to fund its schools. Relative to a lot of states, it's on the poorer side. And so it is putting in significant effort to fund schools related to the total finances in the state. However, it's definitely still funding schools below the national average. So this is data from the Education Law Center. They put out a report every year called Is Funding Fair? They've recently changed it to making the grade, but the basic idea is the same, which is that every year they put out a report about how robust is funding and is it fair. And so 9 out of 10 of the 10 years, West Virginia state and local funding combined is below the national average. The other thing to think about is how is funding distributed? So funding distribution is basically when you have children in concentrated poverty, do they get more? So remember I pointed out that research agrees, scholars agree, that children living in poverty, the types of situations that I mentioned in the poem, that I identified in the poem, need more funding. And so to accomplish that, you need a progressive funding system. That means you give those children more funding. And the record for West Virginia is fairly mixed, as you can see. So you'll notice here I say progressive. So 3 of the 10 years of the report, funding in West Virginia is progressive. That's what you want. It's not strongly progressive, I will say. There is substantial debate about how much additional funding is needed. So some people say it's 40% more funding. That's based on the Title I formula that tries to direct about 40% more funding to children in poverty. Other research studies, however, show that it could be as much as twice as much funding. And so when you only have, it's 10% progressive, even that is likely well short of what's needed. So even when it says it's progressive, it likely still is falling short of the actual need for low-income children to compete on a level playing field with their more affluent peers. What you also see is that 4 out of the 10 years it's flat. So often flat funding is people sometimes think that's what we need. We need everybody to get the same thing. We don't. We don't because some children need more. Just like special education children need more, children in poverty need more. And finally, when you look at other years, you see that children in poverty are getting less money. So that is certainly a concern. And that was the most recent year of data that was shown. So if you see that the most recent data is portrayed here, you see as poverty level goes up across the bottom axis. And when it goes up to 30%, West Virginia is providing less funding as poverty goes up for the most recent data that's available. And so you want to actually reverse that. You want to not only get to be at least at the national average, but you want to give more funding to children in poverty. How does that translate into outcomes in West Virginia? As many of you probably know, so West Virginia students, if you look at all West Virginia students, I have both reading and math scores here. I recognize that's quite a bit of data. But if you look at reading and math in 4th grade, you're ranking 36th and 39th in the nation. Students, however, in poverty are actually doing better than average in the nation for reading and math. If you look at reading and math in 8th grade, you then have an even greater slide. So you're at 45th and 46th in the nation for 8th grade math and reading. And the challenge there, of course, is those students are closer to graduating. So you're starting out, and what the data suggests is that you're doing actually a slightly better job at the elementary, like the earlier years, but the actual progress and relative competitiveness of your students as they move along is slipping a bit as they get closer to high school. All right, so I'm going to stop sharing now and let Josh take over for Q&A, and I'm excited to hear what your questions are.
Yes, thank you so much, Professor Robinson. So for those of you who are on the Zoom, please use the raise hand function and I'll call on you. And then please briefly introduce yourself as a student or faculty before asking your question. Okay, I see a hand from Ian Shoulders.
Hi, thank you, Professor Robinson, for doing this for us. I'm a 2L. I was a teacher before law school for 5 years, actually in Memphis, Tennessee, which is one of the top 10 most impoverished districts in the nation. And I worked in an incredibly impoverished Title I school. And so I'm thinking about this in terms of Title I legislation and how that impacts, because what we saw was a lot of that Title I funding that was theoretically meant to help progressively fund the education of these impoverished students go towards things like teacher professional development, which, we didn't see statistically benefiting those students. And so do you think that Title I modifications is going to play a significant role in this change?
Yeah, that's an excellent question. Thank you so much for that question, Ian. So Title I is definitely the primary federal effort to assist students in poverty. So it's not as though Congress is unaware that we have poverty and concentrated poverty in our schools. The challenge with that approach is that there are multiple flaws within the Title I system. So one of the first challenges is that the formula does not adequately address concentrated poverty. What it tries to do, which is true for a lot of legislation, it tries to make everyone happy. So everyone, across the country, districts with very little poverty get substantial Title I dollars. And so the challenge is you don't have significant recognition of concentrated poverty. That is like one of the primary flaws with Title I. So where you have the kind of school that you describe, they should be getting exponentially more from a school that has 10% poverty or some lower threshold of poverty, right? The challenge is the formula flattens out after a certain level of poverty, and then everybody sort of gets the same. Well, poverty, 90% poverty is different from 30% poverty. You just have a greater host. You saw the poem, you'd get one from every kid with a different situation that's happening, right? And so when you have that, the funding needs to be far more progressive than it is in Title I. And scholars have written a lot about how that should be improved. And in fact, that's addressed in Derek Black also addresses that in my first book, where he gives a number of proposals. But the biggest one is Title I is not doing a great job of addressing the exact situation you said, which is that when concentrated poverty happens, they don't give enough to them. So you have these very affluent districts getting Title I money. And what we should be doing is shifting that title money to schools like the one that you taught in. So that is definitely a possibility for reform. If you fix Title I, it could be better. But I also think we need some new innovation at the federal level, because everyone gets a piece of the Title I pie, and it's hard to take people's pie away once they're used to eating pie. So you just don't want to take the dessert away. Like if you give my kids dessert and you try to take it from them, they hang on, right? They'll fight me for it, right? And so same thing with Congress and districts and money. You hand out money and you say, hey, we're going to redistribute your money to Memphis and Detroit and other places. And the richer districts are like, no, you're not. Like, we're going to fight you tooth and nail for that, right? So that's what happens, unfortunately, Ian. And, so I think partly, yes, Title I should be reformed, but I think we also need some new innovation at the federal level to address these difficulties.
Thank you.
Thank you. Other questions?
I see someone named Jordan. So
yeah, Jordan, go ahead, please.
Hi, my name is Jordan McMinn. I'm a third-year student. Thanks again for being with us. I just had a question, if you could speak some more on, you discussed that we are really looking for an adequacy of education, but as long as school districts and states also maintain some level of local control, the richer, whiter districts can just keep increasing the amount of money they spend. And so how do you think that we should go about ensuring that adequacy increases to the same extent that those wealthier districts are also increasing their spending, and how you go about readjusting what is adequate throughout time?
Yeah, that's a great question as well. So I think that it's essential that we do exactly what Josh has written about, which is that we have to not only focus on adequacy, because you're absolutely right. Then we only get some kids to the baseline level, right? You only get some kids they can barely pass the state test, whereas others are like leaving the state test in the dust. It's like they did it with one hand while they're doing a project. And those are the ones who are going on to, graduate from college and make the higher earning jobs. And so what you have to focus on as well is equity. ensuring, as Rachel Moran writes about, like a right to compete. If the poorest kids can never compete with more affluent peers, then there's something wrong. Education is supposed to be the great equalizer. You know, the founders of our education system, you know, Horace Mann writes about it's supposed to be the great equalizer, education. And in many other countries, it is actually. We are one of the few countries who gives poor kids less funding. Other countries, like all the other developed countries, we are like alone. And this is not American exceptionalism in a good way. This is American exceptionalism at its worst. We are exceptional in that we don't fund poor kids to succeed. And we all lose when we do that because we lose out on what those kids would be doing in our nation. I mean, one of those kids could have come up with the cure for the pandemic, but we didn't give them enough education to do it. Same thing with curing breast cancer, same thing with climate change. Like you have to invest in kids because none of us knows what these kids can achieve. And so exactly what you said is like, we don't want to give just some, you know, some kids get adequate and the others get world class. What we want is to keep equity on the table such that kids can compete with their more affluent peers. There's always going to be a wealth advantage because you can't, until you have a greater investment in our social safety nets, you really can't, it's hard to address what happens, you can't really change what happens at home, right? So those who are affluent have the resource to do all kinds of things. Individual SAT prep, you know, individual language tutors who are helping their child be fluent so they can, you know, test out of their language requirement at college, all kinds of things. So those are the things that you can adjust for, but you can do a better job in the schools of making them the great equalizer that they were created to be. We've just simply failed. And I think we've chosen to fail because those who are in power benefit from the current system. I've definitely heard, I can't remember who said it, but someone once said, if we had the members of Congress, their children and grandchildren all had to attend our nation's worst schools, we would get federal legislation like that. We'd be like, wait a minute, what? Like our kids have to go to these schools? But the challenge is because those in power, because it takes so much money to win in political office, their kids aren't at the worst schools. They don't feel it the way that the people in the schools do. And so we have to raise our voices to demand that we give those kids what those congressmen and women want their kids and grandkids to get. And so that is what I see my calling to be.
Thank you. Other questions? Ben.
Hi, Benjamin Vanston. I'm a 3L. So if part of the reason why we want a federal right to education is to create this federal action on education to enforce the right, how will suing states like in Gary B help compel Congress to actually do that? Would states turn to Congress to exert pressure to spur action, or how do you see that playing?
Yeah, so what's the intersection between Congress and the court? Yeah, so I mean, there are multiple paths to get to a federal right to education. Actually, one of the chapters I contributed to the book is saying that Congress, even without the court acting, could recognize the federal right to education. You just have to find the political will to do so. And so if the court recognized legislation, it undoubtedly would influence what Congress does at a minimum in the reauthorizations of the Elementary and Secondary Education Act. In other words, you would have fundamentally changed the landscape of education once there's a federal right to education. And so Congress isn't going to bury its head in the sand and not acknowledge that when it's reauthorizing federal legislation that impacts all the schools. So I do think that there would be a dialogue between the legislative branch and the courts over how this right should be ultimately protected. How that would play out, it really depends on what the court says the right is. You know, some people actually have criticized the Gary B decision as setting too low of a bar. It's like if we're just getting kids to the fundamentals of literacy, that's not really going to change the landscape, probably for many of the kids in West Virginia. It's just going to hit the very bottom. But for others, that's raising the bar. So that's why there's quite a lot of debate about what the right should guarantee. But what I really believe is that we all should want an education system that gives what we would want for our own children. And I have very high what I want for our children. And so I think every child should get access to an excellent education system. And that's what we need to invest in.
Thank
Thanks for the question. It's a great one.
Okay, other questions, please? Alex.
Hey, my name's Alex Masholi. I'm a 3L. I have kind of a different perspective on this. My mom was a special ed teacher in Preston County, which is kind of a very poor rural area, for about almost 40 years. And I taught in alternative schools for most of my career before law school, kids with behavioral issues and things like that. How, because I mean, you talk about the kids who are in the poor areas not receiving, their fair share of the money. How do you take that a step further and say, not just the poorest kids in traditional classrooms, but the kids who are also in alternative schools and that sort of thing? Because I know a lot of the issues with the teacher strike, they were addressed as far as traditional classrooms go, but I didn't hear very much about, my small little classroom with 8 kids who 2 or 3 times a day I had to restrain one of them, or, you know what I mean? Like, it's kind of a different perspective, I know, and it might not be what we're discussing, but how do you advocate for those kids as well without kind of overwhelming whoever you're advocating to with sort of the administrative burden of all of this?
Yes, no, that's an important question, because I think what you're sharing with a lot of people in the audience, which many people may not know, is that alternative schools provide education for many children who've been, have been suspended from school. The idea is to make sure they still get an education while they're being disciplined. The challenge, of course, well, I shouldn't say of course, the challenge that we have created is that they get inferior educational opportunities. And so I think that is a multi-part problem. So one is how we understand youth who are being disciplined. I think that we tend to kind of scapegoat kids that are being disciplined. But if you look at the research about the school to prison pipeline, what you see is that we've increased the criminalization of what used to just simply be kids being kids, right? So a kid getting in a fight, now they end up at an alternative school. When I went to school, they would end up in the principal's office and their parents are called in, and then they might be disciplined, but they're not kicked out of school. They're back at school the next day, right? There may be detention, but they're not in an alternative school. So part of it is that how we're disciplining children is really very much broken. Like we've over disciplined, and that had a lot to do with zero tolerance. So we had federal legislation and other legislation that said zero tolerance in the schools for certain things. So we pushed a lot of kids out of school and into alternative schools where they're getting lower quality education. Now, even if we keep alternative schools, which we're going to need, it does not have to mean that those kids get any less than other kids. The problem is we don't invest in those kids. I think people justify it as, well, they're the quote unquote troublemakers, right? They've caused trouble. This giving them less is okay. It's not okay. We're underinvesting in these kids when we could turn them around. Turn around their opportunities. Some of what they're dealing with is exactly what I showed in the poem. They come to school after dealing with a very difficult home life, and learning algebra is not the first thing on their mind. The first thing on their mind might be, the fact that they walk through a very dangerous neighborhood, or a situation at home. And so it's important to understand that the children who are in alternative schools are our children. And I think we've lost that sense of our children for schools. We talk about other people's children. And I think that drives a lot of what we're doing. Again, put some of these congressmen and women's kids into an alternative school. You're going to see federal legislation about alternative schools. I mean, it's just, we're underinvesting. And so I think it's partly, part of what I see my work being is like raising people's consciousness about these issues. And so you, with a law degree as a law student, you could be the one to help raise people's consciousness about alternative schools and say, hey, our education laws apply to them too. We've got to fix this disparity. So you could be the one that changes that. And I always tell my law students, you are the social engineers of our time. So all of you who are there now getting an education can be the ones who help to fix this system, because it is broken and it needs your help.
Amen.
Thank you.
Professor,
Amen. You can pass the plate later.
Professor Hott, I saw your hand. Did you have a question?
I did briefly. Thank you so much, Professor Robinson. I was just struck by some of what you were saying about how do we get people to feel it and how do we raise the consciousness. And as you know, a mom of a second grader who just sat in the other room watching 19 other children struggle with even finding the materials that their parents sent home with them. Do you think that the pandemic actually is an opportunity to raise the consciousness? Because I can tell you, I've been virtually heartbroken every day.
Yes, it is. I do think it is. I'm trying to, this pandemic is taxing, right? It's taxing all of us in so many ways. But I think there is an important opportunity because one, society realizes now we need the schools. We need the schools to function. Like this, the economy is slowing down partly because parents can't get to work, right? And so I think what's being laid bare is that we've underinvested in schools. We certainly have underinvested in infrastructure. So part of the reason some of these schools can't reopen is not that you can't get a schedule where you alternate days or you divide them up in pods, is that you neglected the facilities for so long that you can't get the air clean, the infrastructure, the HVAC system, all of that is not working well enough, and the sinks are broken. You can't get kids back into school to say, wash your hands all the time. How are you supposed to do that with two of the sinks broken with, tape across over them? So I think in terms of raising the consciousness, the pandemic can definitely do that. But I think also, I can tell you what I do with a lot of my students is I take them into schools. I can't do it now, unfortunately. But I've taken my law students into schools. So I took them when I was on the faculty at University of Richmond. I took them to a Richmond public school, then I took them to a suburban school up the street from me. And talk about understanding the opportunity gap in ways that will stay with you. And I have them I divide them up and send them in pairs into classrooms, and they sit and watch what's happening in the learning environment. And they saw schools where one of my students was so moved. He saw a kid learning from the textbook his district had discarded years ago, that he had used many years ago, and that was out of date. And he's like, I just want to call my district and have them donate. He really I want to fix this problem, right? Same thing. We went to the suburban schools, everybody's on their own computer. It was a completely different situation. So I think we have to spend more time in the schools and get people in there to understand it.
Sean, you had a question?
Yeah, hello, Professor Robinson. First, thank you for taking time to come speak to us today. I'm a 2L here at the College of Law, and my question deals kind of with a line drawing problem. Our goal is to achieve adequacy or equity or combination of both, to me that speaks to a form of testing. And I think, at least in some way, you're going to end up testing the students to see if this is achieved. And I hear complaints from teachers that we've already tested students into oblivion and that an education system focus already too much on standardized testing. And especially if you have federal monies at stake, I think there's going to be a heavy emphasis on this in the school. So how do we avoid a diversion of goals there?
Yeah, that's a very insightful question. Yeah, how do we avoid a federal right to education becoming like the federal right to testing, right? Definitely, that is not the goal. And so that's an important question to think about. I think it's partly to understand that, testing and assessment are two different things, right? So you talked about standardized testing. That's one way to test students. But assessments, which can be multifaceted, they can be, projects, they can be presentations to the classroom. I actually gave my 9-year-old a voluntary presentation. I voluntold her to do a presentation on something that we're learning for class. But there are just a whole bunch of different ways to assess learning, right? It doesn't have to be, she's not doing a paper and pencil test about that subject matter. She is going to present a set of photos that we took to show what she learned, right? So there's an entire body of assessment that has become conflated with standardized tests, and the two need to be separated. You can assess learning without doing a standardized test. And so I do think you're right that federal funding and involvement often involves different requirements, but some of the requirements are about the input. It's not about outcomes. We're generally not trying to achieve equal outcomes. That's just that there's a whole bunch of other factors that go into that. But assessing opportunity and understanding adequate and equitable opportunities is really about assessing what's going into the schools and classrooms, less about making the kids sit down and do a test. So I think it's important to understand there's a difference between closing opportunity gaps and closing achievement gaps. We definitely want to do both, but we have neglected the opportunity gap. Who gets what resources? And instead, we focused on the achievement gap. Let's just keep testing them to see what they're learning. Well, it's sort of that analogy of you can't make a cow gain weight by weighing it over and over. You can't. You have to change what the inputs are.
Okay, we have two final questions.
Great.
Ben, you want to go again?
Yeah, I guess it's building off of Sean's question is if in a theoretical sense we have this well-established, robust federal right to education, do you think that there would be still leeway for schools to experiment locally and possibly remove themselves from the factory model, or do you think that Congress would push requirements onto states as a result of funding that is largely based on assessment, like tests and assessments that embrace the factory model?
Yeah, so I think that local control is the biggest pushback you get on a federal right to education, state and local control. And so the question is, does that leave? Do we all become a federalized education system because you have a federal right to education? I don't think there's any danger we're ever going to have a federalized education system in the United States. We're just never going to get there. But what we can do is set a floor of equity and adequacy and say that it's no longer okay to give poor kids a worse education. It's no longer okay to have state funding systems that are not even tailored to achieve what they're designed to achieve. Their state funding systems, often people are shocked to find that the way you create a funding system is not always let's look at what kids need to learn and the opportunities they need to do it and then fund that. You would think that that's what happened. The school finance litigation has laid bare that no, what they do is they look at how much money is available in the budget, they divide it up among the districts, and they distribute it. And that has been one of the great achievements of school funding litigation is hey, the reason this doesn't work is because they never planned for it to work the way it's supposed to. And so I think it's important to understand that, you don't, how the money is spent, as long as it's not consistently favoring the rich over the poor, would not mean that you couldn't innovate with what you do with that money once you get it. I think experimentation and opportunity could still thrive in that environment.
Jordan, you get our last question.
Hey, surprise, surprise. It's actually Bryce.
Oh, hi, Bryce.
Hello. Thank you for speaking to us. I am here with Jordan. I'm also a 3L. I wanted to ask you, what do you think the political fight would be to gaining a federal right to education, whether that be through constitutional amendment or federal legislation? We live in a world where the Equal Rights Amendment was almost passed because on its face, you just say, hey, women should be treated equally. And I think on its face, a federal right to education, most people, red states or blue states, would be behind that. But as you know, the Supreme Court decisions don't really come out that way. They come out very ideological. And so how do you foresee that playing out on the national stage?
Yeah, so it's a great way to end to think about. So I think in terms of the politics of a federal right to education, I mean, it's interesting when you ask people, do we have a right to education? Most people think they already have one. So it's fascinating when you talk with people, it's they think that they have some guarantee of education and they actually don't. It's not protected in federal law. And so I think it's partly trying to understand what it would involve and what it wouldn't involve. So the prior question about, oh my gosh, are we going to end up with like cookie cutter factory schools and nobody can innovate and do their, have unique schools? It's important to understand what it's not. It is not saying we need schools to all look the same. It is really about, an education approach that recognizes that children need both an adequate and equitable education. So I think part of the political will comes from education, meaning educating people that we have a very broken system. And the pandemic, as it goes to the earlier point, the pandemic is laying that bare. Like we have quite a broken system. And so what do we do about that? So I think that's part of it. I think part of it is also helping people understand that changing our approach to education federalism, so I write extensively about this, we need to understand that the states do some things well. They don't do equity and adequacy that well. And so you have to let the states innovate and experiment. They do that well, but they don't protect our most vulnerable very well. The feds have a superior track record on that. And so we need to let them partner with, not take over, partner with the states to achieve these national goals. And so I think it's a long, hard fight. I think a constitutional amendment is the least likely because it's such a difficult process. But I think that getting legislation or getting a Supreme Court decision is more within the realm of possibility, for the next half century. So before you jump in, I just want to say how pleased and excited I was to talk to everyone in West Virginia. My father-in-law was born in Charleston, John Robinson. And so our family was really excited that I could talk to an audience in West Virginia because I wouldn't have my two kids without West Virginia. So I'm very excited about the opportunity to talk here. So.
Well, that's all we need for us to consider you family, Kimberly. So you are always family now, and welcome to come back. And hopefully we'll have you back in person very soon. But thank you so much for joining us.
Yeah, thank you for having me. It was really a pleasure and great questions. I love what your students are learning. So
thank you so much. Thank you all.
Thank you. Yeah, thank you so much, Kimberly. Thanks, everybody. This was wonderful.
Thank you so much.
Thanks.
Excellent lecture. I know my students, they've been emailing me during the lecture, so they came, and I'm very happy about that. So thank you. We have a lot to think about.
Awesome. Thank you so much.